With that, I'm going to turn the time over to Julie Rose, who is our moderator, and take it away, Julie.
Thank you, Peter. Welcome to the BYU Copyright and Trademark Symposium debate. It's the third time we're doing this, and I have had the pleasure of moderating all three of these, well, two, and now this one. Today, the debate is on the moral right of creators to control their works. By the way, my name is Julie Rose. I host a daily interview show called Top of Mind. It's heard on Sirius XM satellite radio and also byuradio.org. So let's begin. For 20 years, graffiti artists covered every inch of a warehouse complex in Queens, New York, with their swirling street art. The developer of the block welcomed the artists, and over time, this whole complex was dubbed 5 Points, a United Nations of graffiti, an open-air aerosol museum. But the day came when the developer followed through on the plan he said he'd always had, which was to demolish the warehouses and build high-rise condominiums. Tearing down the buildings with all that glorious graffiti on it, he said, would be too heart-wrenching. So one night in 2013, the developer had the walls whitewashed. A year later, the complex came down. It was a sad moment for the graffiti artists. But the owner of the property, he owns it. He can do what he wants, right? Well, the Visual Artists' Rights Act of 1990, or VARA, says sometimes when a piece of art like a mural or a sculpture is sufficiently well-known or important, the owner of the property can't just destroy it without warning. VARA gives painters, sculptors, photographers some control over what happens to their art, even if it's on somebody else's property. A mural can't be mutilated or modified without the artist's approval, for example. While the copyright law in the U.S. looks primarily at a creator's right to benefit financially, the Visual Rights Artists Act of 1990 recognizes what are called moral rights. Moral rights have nothing to do with making money off of your art. It's more personal than that. It's an artist's right to say, there's a piece of me in that painting or sculpture, and what happens to it matters to me. So back to 5 Points in Queens. 21 of the graffiti artists sued, and last year a federal judge in Brooklyn awarded them $6.7 million. The judge said dozens of those ruined murals had enough artistic stature to merit being protected under VARA. The developer of the property is appealing the judgment and continues to argue that the graffiti artists knew his arrangement with them at 5 Points was always just temporary, that at some point he was going to build those condos. Recently, the U.S. Copyright Office completed a years-long review of how well existing copyright laws protect the moral rights of creators. Took lots of public comment, and the office issued a lengthy report that concludes, essentially, the patchwork of laws in place, including the Visual Artists' Rights Act of 1990, seem to be sufficient. Now, plenty of legal scholars and commentators disagree with that finding. So today we are going to hear both sides of the argument. We are going to have this debate Oxford style. So we've got two teams who are going to debate the issue, and you, the audience, will decide who wins. Now, in order to do this, we first need to know where you are right now on this issue, so that at the end, we'll be able to know which team has convinced the most people, and that'll be the team that wins. So if you would please take out your smartphone, your mobile device, anything that's internet connected, computer works, go to this address, meet.ps/BYU Symposium, and indicate whether you agree, disagree, or are undecided with the following statement. United States law sufficiently protects the moral right of creators to control their works. All right, let's meet our debaters. Arguing for the proposition, we have Kathleen Smith, professor of law at the University of Montana, and we have Jennifer Hutchins. Hutchins or Hutchings? Hutchins. We have Jennifer Hutchins, who is founder of Alada Action Advertising in Oklahoma City. She has a very interesting story. There was a mural of some children playing in a lake on the side of the Alada Action Advertising building that Hutchins and her landlord didn't really like, so they painted over it And then the artist of the mural sued them, and the case settled last year. So please welcome Kathleen Smith and Jennifer Hutchings. On the other side of the debate, arguing against the proposition, we have Sue Liemer, who is a professor of law at Elon University, and Jan Martin, an artist in Indianapolis, who sued the city when it destroyed his street sculpture, Symphony No. 1, without warning. Martin was the first artist to win a case under the newly enacted Visual Artists' Rights Act of 1990. So please welcome Jan Martin and Sue Liemer. Each member will have 5 minutes to deliver an opening statement. And then we'll have 30 minutes for the teams to question each other and to take questions from you in the audience. After some brief closing statements from each side, we'll come back to you to register your vote again, and then we'll compare the vote tallies. And whichever debate team has changed the most minds over the course of this debate will be the winner. Again, the proposition is, United States law sufficiently protects the moral right of creators to control their works. And Kathleen Smith, arguing for the proposition, will speak first. Let's see here. Okay, there you go.
All right, thank you. Good morning.
Oh, let's get that on.
Might be off.
There you go.
Can everyone hear me? Yes. My name is Kathleen Smith. I'm really happy to be here today. My partner Jennifer and I are going to argue.
It's right there on the screen.
It's right there. That United States law sufficiently protects the moral right of creators to control their works. In other words, we are taking the position against expansion of stronger moral rights laws in the United States, including expanding moral rights law to cover things other than visual art, including literary and musical works, which has been suggested by scholars in the past. But first, I want to just make two clarifications. When we first hear of moral rights, sometimes what jumps to our mind is morality or immorality in copyright law. And this is not about immorality in copyright law. Moral rights is basically about the right of an artist to control their work, the right of a creator to control their work, even after they have sold that physical piece of work, and even sometimes after they have transferred the copyright to their works. The second clarification is our position in this case. Right? We are not up here arguing that we want to abolish or dismantle current moral rights laws in the United States. What we are arguing is that current moral rights law strikes an already precarious balance with private property rights, with free expression rights, and that we are arguing against the expansion of further moral rights here in the U.S. And there are a number of reasons that we're going to support this position in this debate today, but I'm going to use my time to just try to cover three within my 3 minutes and 23 seconds left. First one, and the one that I find the most persuasive, and I have written about in the past, is that the expansion of moral rights in the U.S. by granting creators more control over their works can have the effect of actually stifling, censoring, and chilling further expression. Now, consider the moral right of integrity, which grants a creator the right to prevent the intentional distortion, mutilation, or other modification of their work that would prejudice their honor or reputation. Creators should be able to use other people's works to make social, political, and artistic statements. These are things that we as a society encourage. We embrace this freedom of expression. Right? It creates discourse. It can educate us about our history. It can bring awareness for gender inequality, for instance, on Wall Street, which is what Fearless Girl did when the artist placed Fearless Girl in front of Charging Bull. It can provide social context, reinterpreting or shining a new light on sculptures, for instance, that glorify the Confederacy or sanctify genocide. And it can educate, such as here, showing in the image, where red dots are placed on this significant image of the Declaration of Independence, highlighting the men, each and every single man who owned a slave, featured in this photo. Expanding moral rights in the U.S. could stifle this free expression. Now, imagine if moral rights of integrity were expanded even further in the U.S. to cover works beyond visual art, literary works, or musical works. This right could easily be used to stifle and chill commentary, criticism, parody of the creator's works under the argument that it would harm the creator's honor or reputation. One example here that I'm showing, if moral rights were expanded to cover literary works, Margaret Mitchell's estate could have asserted that Alice Randall violated Mitchell's moral right of integrity when she wrote the parody, The Wind Done Gone, that criticized Gone with the Winds, romanticized a vision of the antebellum South during and after Civil War. Randall's work certainly altered the meaning of Mitchell's work, harmed her honor and reputation, but Randall's secondary work is the type of new expression that we want to encourage. We want to encourage this type of criticism, this type of commentary that could be stifled if moral right of integrity were expanded here in the United States. The second reason for not expanding moral rights is that current moral rights laws strikes a difficult and sometimes precarious balance between artist rights on the one hand and private property rights on the other. Should a property owner, for instance, be forced to curate art that she opposes, that does not reflect her message, or is that she perhaps is morally opposed to? What if, for instance, the property you purchased had a mural up there that you found to be racist or sexist? Should you be able to alter that work, destroy that work, or should the artist's moral rights control over your private property right? Finally, the U.S. current moral rights law sufficiently protects artists' control over their works. My debate partner, Ms. Hutchings, can attest to this. She just settled a 2-year lawsuit where she was sued for destroying a piece of mural that she disagreed with. Jan can also attest to this because he sued the city of Indianapolis and won his moral right of integrity suit.
Thank you. Thank you, Kathleen Smith. All right, now we are going to go to the team arguing against the motion, and we will start with Jan Martin. And I need the clicker. Here we go. Oops, hold on.
Excuse me?
There you go.
July 20th, 1995 is the day that the city of Indianapolis bulldozed my sculpture. They never admitted making a mistake, nor did they apologize. Nothing can be done to restore the lost time, energy, and devotion required to create a large work of art that defines who you are as an artist, the moral right you possess and wish to protect. In 1997, I returned home to Indianapolis from New York City with my family. Indiana, no place, was not known as a cultural center for the arts. The downtown was dead. As the mayor recalled, you could shoot a cannon down the street after 5 o'clock and not hit anyone. The city only had 4 public sculptures. One of them, called Snowplow, was a plow blade coupled with a giant rubber tire. I decided that I would use my talents to jumpstart interest in public art by creating a large sculpture I named Symphony No. 1. It would be unique, different from anything else yet created. It took me 2.5 years to complete and 1,300 hours of labor on the weekends. 8 years later, the city, referring to it as a lawn ornament, had it destroyed. The estimated cost to replace it in 1997 was $150,000. So you may be asking, why would the city do such a thing? In 1982, the property where my sculpture was to be placed and that of the homeowners and businesses that bordered the old city canal was blighted by the city. This was done without giving public notice as required by law. In 1992, when the city's real estate consultant visited our family business, he informed us that the blight designation meant that the city would invoke the right of eminent domain if we just did not agree to their market evaluation. In response, I joined the neighborhood association to protest against the city's land acquisition and put it on hold. They put it on hold. During that time, I submitted a plan to the city that would allow our business to remain. I proposed an ornamental wall that would conceal our building. The wall included sculptures and metal murals compatible with the canal's design. When the land acquisition resumed, it was reported that the city had been negotiating with favored developers, offering them tax abatements, enticing them to buy devalued land from the city to build apartments and condos. The strategy was meant to lure more people to the downtown. This was understandable. The problem arose in the method they used to do it. Blighting the land automatically reduced the fair market value. In the case of our company, that lowered value would affect our ability to stay in business. Long story short, our company worked out a land swap deal with the city. During the contract signing, I donated my sculpture to the city, believing that it was a significant gesture in line with the city's desire to improve its image. After all, the regional plan they were advancing spoke of providing stronger support for the arts, stating that there was not enough civic pride in local artists and art programs. Sitting next to me at the signing was the city's acquisition manager. It was proclaimed that he would contact me if the sculpture was to be moved. Destruction was never mentioned. When he was deposed by my lawyers, he swore that he had no recollection of my verbal donation. His notes said otherwise, quote, "Sculpture, need letter from DMD. If not used as artwork, then it should not be destroyed. Jan Martin would like to reclaim." 2 years later, he signed off on the order given by the director of Department of Metropolitan Development to destroy the metal sculpture. Even more reproachable, the city dishonored a legal agreement I had with the DMD. It stated, should the sculpture no longer be compatible with the existing land use or acquisition of the property is necessary, the owner of the land and the owner of the sculpture will receive written notice signed by the director of DMD, giving the owner of the sculpture 90 days to remove said sculpture. My case against the city under the VARA law ended with a judgment awarding me the maximum statutory damage of $20,000 and all my attorney fees that approached $170,000. But it denied my appeal for $100,000, claiming that the city did not willfully destroy my sculpture. The director of DMD and the acquisition manager testified that they never heard of VARA. Thus, the judge concluded that the city could not have willfully destroyed it. The appellate court agreed. In conclusion, the city of Indianapolis advocated in its plans for the future that the goal of the arts is to establish, as a matter of public policy, a vigorous and healthy arts community as a major priority for a high quality of life. I think I tried a little harder to achieve that goal than they did.
Thank you. We'll now go to the team arguing for the motion, and Jennifer Hutchings.
Let me take y'all back 3 years. 3 years ago, I had owned my business for 7 years, self-made woman, did not come from wealthy parents. Everything I have made, I've earned with my own 2 hands. And I was about to move into a new space, expand my shop 5 times its size, from 900 square feet to almost 5,000 square feet, in a very creative area on Western Avenue in Oklahoma City. And I was supposed to move in on March of 2017. Took my first vacation in about 4 years in February. Hadn't moved in yet. All I had done was signed the lease with my landlord, agreed on a paint color for my building, and I had a move-in date. It was going to be ready when I came back from vacation, and it was going to be great. Well, I thought. Then I get a phone call when I am in Key West on vacation from a journalist disguising himself not as a journalist. "Hi, Jennifer. I'm a friend of your sister's. I just wanted to call and congratulate you on your new space." "Well, thanks. Oh, and by the way, why did you paint over that Robert Palmer mural?" "Well, I thought it was ugly, and I don't even know who Bob Palmer is, but I'm going to paint a new one over it." Whoa, wrong answer. That sparked a huge national debate of hate mail, hate voicemail, hate email, picketing. They tried to boycott my business. Over 3,000 negative comments immediately overnight went viral that I was an art hater. They called every one of my customers they could find on my website and social media to boycott me, that I am an art hater. And here I am on vacation, bawling my eyes out. Don't really know what I did. I didn't even paint the building. My landlord painted the building. His contractors actually painted the building. I didn't paint it. My landlord didn't paint it. But everybody jumped on the bandwagon because they found out this a lot of action girl is moving in and she's an art hater. So thus, the stigma got stuck on me as an art hater. And nobody knew the facts. And I couldn't even talk about the facts because it was just, I was so more worried about, okay, I need to delete these comments. I need to cover my reputation because I've worked very, very hard to build my own business these last 10 years now. So I write a press release after the storm comes on me and basically say, "I'm sorry, PR isn't my thing. I should have used, better words. It's just not my taste. But here I am paying premium rent on a new space, and the whole reason why I got this space on Western was so I could put a big, beautiful mural of my own taste, of my own liking, on this sky-high rent property that I'm getting. Well, I couldn't do that. Everything came to a halt right then. The battle began. I got served by a federal marshal, 2 guns on her hip. She came in my office, served me paperwork. I had no idea what was going on. We fought for 2 years, actually 2+ years. Then became more lawsuits after that. The Western Avenue Association came after me. The United Insurance Company came after me because I refused to file all these claims on my own small business insurance. Here I am defending my right to put my own taste and liking on my building that I'm paying for, that I've worked super hard for to get. And these people are just awful, picketing, following my employees home, spray painting things on my old property. Like, it got really, really ugly. People were really hateful to me. I just want to read just a few of some of the comments that I dealt with. This is, one of several thousand. A lot of Action Agency is going to see no customers at their new address. Such insensitivity and cowardice in the aftermath. I'm on vacation. Tells one all they need to know about contracting with a business and how they might treat a conflict down the road. Other artists will be turned off by this nonchalant attitude and not want to waste their time sharing their visions with Oklahomans. She obviously feels no shame at all. I will not be shopping there. That's right, no shame. Next one. Tasteless and listless. Go read some Rookmacher. Jennifer, at a lot of Action Advertising, do not deserve your business. Do not patron this establishment, nor any other businesses affiliated with Jen Hutchings. Let Jen Hutchings know that people like her will not thrive in Oklahoma City. What a bitch. What a cunt. Seriously, is she so entitled that it didn't even occur to her that she might need permission before painting over a work of art? This is just one of thousands and thousands that I got. And it was hard to deal with, but I stuck the course. I took the higher road. I fought and I fought and I fought and I fought. And I wish I could tell you how it ended, but I'm not allowed to do that.
Thank you. To be continued. We'll turn now to the team arguing against the motion and Sue Liemer. There you go. It's there. Let me see that. Oh, you want to back it up?
Hi. The professors in the audience will understand it's very hard to talk sitting still. I'm used to wandering around. So to begin with, the moral rights protection that we have in the United States cuts out huge swaths of art and artists. Literary artists writing in any genre are not covered by moral rights in the United States. Performing artists in music, theater, dance, opera, etc. are not covered by moral rights.
Okay, we will now move on to round 2 of this debate. The debaters will take questions from each other, maybe from me, but also from you in the audience here at the 2019 BYU Copyright and Trademark Symposium debate. If you would like to ask a question, we have a couple of roaming microphones. We are recording this for podcast, so please wait until you get a microphone in your hand in order to ask your question. We'd also ask you to make it a question rather than a comment, and to keep it concise. We'll have 30 minutes for this question and answer session, and so we want to make sure we get the most of it. Now, as a reminder, the proposition for this debate is the United States law sufficiently protects the moral right of creators to control their works. We have heard from the team arguing for this motion, Kathleen Smith and Jennifer Hutchings, that the current law strikes an already precarious balance between the rights of artists and private property rights in America. This team has indicated to us that they are not arguing for that they say that expanding moral rights can stifle or censor free expression, and that they are not arguing against moral rights themselves, but rather arguing against the expansion of these rights. And we've also heard the example of Jennifer Hutchings and the mural that was removed from the side of the building that she owned, and how she feels that infringed on her private property rights, the criticism that she received. The team arguing against the motion, Sue Liemer and Jan Martin, have told us the story of Jan Martin's art, which was destroyed by the city of Indianapolis. And we've heard that moral rights, the current law is limited. It's restricted only to a certain subset of artists, that it does not cover literary and performing artists, that it also only covers a certain subset of visual art under VARA, and doesn't cover things like calligraphy or fashion design, as many other countries do, that here in the United States, our moral rights protection is much more limited, even does not extend to an artist's right to control the placement, the lighting, the location of a piece of art. And that because of the way the legal system is set up here in America, artists will often waive their moral rights because they are not in an economic position to do otherwise, may not even realize the rights that they have. We will now take questions from each debate team. So I'll just let you both, if one of you has a question for the other side, please go ahead and do that, and then we can take turns from there. Have you got any questions? Cathay, would you like to ask a question, Jennifer Hutchings?
Yes, ma'am.
Please go ahead.
Jan, I have a question for you. If somebody what is the difference between exercising your moral rights versus just being offended?
Well, in my case, it was a destruction. So I lost something that I had made. So yes, I was upset, but it was more importantly, it's gone forever. So it's a whole different emotion. And I certainly didn't prepare or didn't think this would ever happen. I just never imagined it. So.
Do you have a question? No. Do either of you? Sue Liemer.
So what I thought was striking in Jan Martin's case, although he did win the case and he won the basic copyright damages of $20,000, was that the court made a distinction between willful destruction of the work, which it found, by the way, had happened, and willful infringement of the moral rights. And somehow ignorance of the law was an excuse in that case because they did not know. And so I suppose I'm asking the other side, how is it that you could willfully destroy a piece and not be willfully infringing on someone's rights?
Would you like to respond?
In my opinion, I wasn't willfully destroying anything. That mural had been up for 3 years. The facts are it has been chipped. We had over 20, 30 citations from the city to fix it. The facts were the VERA waiver was actually forged by the same people who were suing me. So I just have little sympathy for the. It wasn't intentionally me as an art hater wanting to destroy this. It was I'm paying premium rent and I want to express myself now. Like I feel like the only constant is change, and that mural was not in its best shape at that point, and I didn't even paint it over. Had I known about the law, which I think I was the third case in U.S. history that had this happen, not many people know about that. And if it wasn't the third, it was a very small number of cases that have taken the VERA Act to court. So I did not know. Neither did my attorneys. Nobody knew about this VERA Act. It wasn't something like when you go buy a house and there's somebody else owns the title, you are presented with that. Nobody presented me, okay, this is some piece that's got to be protected. Nobody knew. That was the first time that this had ever been heard of in Oklahoma City, for one.
Kathleen Smith, yes.
Yes. And so I'm really sympathetic to the story of artists who create art. Mr. Martin, I teach your case in my classes at law school, but I don't see where the expansion of U.S. moral rights would have changed the outcome in that case. I do think that we need to clarify some of the terms currently existing in the statute. I do agree that there needs to be more education of what the laws we currently have are so that people know when they can and cannot alter or destroy works under the current law. But I do not think that it would have changed with an expansion of moral rights. In fact, I think your case almost shows us that currently moral rights are working. Right? You were able to take current law, sue the city of Indianapolis, and win under a violation of your right of integrity. And potentially you also had a breach of contract claim, right? Because there was a contract saying that they would inform you before they would destroy your work. And so with the breach of contract claim, with the current moral rights law in place, it seems to be serving creators, just like I think Ms. Rose mentioned in the beginning in her intro. The 5 Points street artists were able to sue the developer and were able to win that case. And I think, I can't remember, it was $5 million.
Yes, $6.7 million, I think.
$6.7 million under the laws that we currently have. So I maintain our position that that moral rights law should not be expanded, and it sufficiently serves artists and creators.
So the 5 Points case was decided in the Eastern District of New York. It's up now in front of the Second Circuit. We're waiting for a decision from the Second Circuit. The judge in the trial court and in other VARA cases that have come up, the judges have been clear that often the appropriate remedy in a VARA case is more in the nature of equity than law. Because obviously giving Mr. Martin $20,000 is not bringing his sculpture back. If we have a temporary restraining order and then a preliminary injunction, it was at the preliminary injunction stage that things got dicey in the 5 Points case, then we can protect the art. And there is technology now that allows us to take murals off of walls and graffiti off of walls and protect it and move it to other locations. We didn't when VARA was first passed, but we do have that technology now. In the 5 Points case, they had the temporary restraining order in place. The artist had gotten that. The artist tried everything they could do before that, by the way. They went to the city planners. I forget in New York City exactly what that organization is called, that entity is called. But they tried to get registered as a landmark for protection of the work. And the city law required the attraction to be at least 30 years old. And it wasn't, even though the building was really old. It had been, I think it had been like a parking meter factory at one point. And so they couldn't get their landmark status. The artists among themselves, with a lot of public sentiment on their side, raised $30 million to try to buy the property. Then the property owner received certain special permissions from the city and the clearances that they needed to put up a luxury condo complex. And overnight, the value of the property, you had to add about $200 million to the value of the property. And so the artists they couldn't do that. So that's when they went to court for a temporary restraining order, which they received. Then when 14 days later, when they had to get the permanent injunction put in place, at the hearing from the bench, the judge indicated he was upset with the behavior of both sides because some of the artists had done some of their works after they were told that the building was coming down. So he said they brought it on themselves. He was upset throughout the entire proceeding with the behavior of the property owner, who the judge found out later had lied. The property owner had indicated he had the demolition permits, and the buildings were coming down pretty imminently. The judge found out only afterwards that those demolition permits had not yet been issued, and it was about 4 or 5 months later that they were. And so from the bench, the judge indicated at the permanent injunction stage, the judge indicated he was not really inclined to grant the injunction, but he was very shortly going to have a written decision. And it was the night before his written decision came out, and it was at night, under darkness, that the property owner sent his workers to whitewash the building and destroy the artwork.
If I may, my understanding of VARA, not being a lawyer, is that the protection against destruction applies specifically or in particular to pieces of art of recognized stature. Cathay Smith and Jennifer Hutchings, you argue that we should not expand moral rights law. Does the current law clearly define what should be considered recognized stature and what is just plain ugly or offensive and can be removed and destroyed?
I think there are a couple of things that we're going to agree on, and that there is no clarity, right? There is no clarity on how do you determine recognized stature. There should be more clarity on that, but that does not equal expansion of the rights under moral rights. That's just taking what we have now and making sure that everyone is educated and understand what they can and cannot do under current law.
And Sue Liemer and Jen Martin, should a property owner be required to maintain a mural or a sculpture on their property that they find offensive, that even other people maybe in the community find offensive? Under moral rights, are they obligated because someone put it up at some point and now it's the property owner's responsibility to maintain this thing they find upsetting?
So in VARA, within 106A, there's a reference to 113D. And 113D does provide for 90 days notice from the owner of the property to the artist. And it's a provision basically to work it out, to talk to each other, to let's come to some understanding. And so if you don't like or if your taste has changed, whatever, you talk to the artist. Even when I teach copyright law, I always tell my students, just ask. You can go a long way just asking. Not everybody's going to give you copyrights. Not everybody's going to give you permission under VARA to change or to destroy their work. But you don't know if you don't ask and you don't have a conversation and try to work this sort of thing out. If you send the bulldozers to the property when the artist has already contacted you, it's hard to say that we're protecting these rights. When somebody buys a building, it's not unusual in this country to have restrictions on it, to have encumbrances on the building. We know about those sort of things as attorneys, that you have to go and research these sort of things. We have historic registries where you cannot change a light fixture on your house or the color of the paint of your building, even if it doesn't have artwork on it, unless you get permission from the Historic Registry Commission in your town or in your state. We have environmental protections that say undeveloped land can't be changed. You may be a logger in Oregon and you want to use the forest that you've just bought, but you can't if we're protecting the spotted owl. We encumber real estate all the time in this country. It's a question of which things we're going to put values on.
Thank you. Are there any questions from the audience here? Okay, let's go ahead and get microphones. Here's a microphone coming here in the front. If you'll please introduce yourself and then, of course, keep your question concise.
Good morning. My name is Bobby Schwartz. My question is to the side of the debate.
Yes, the team in support of the proposition. So we've got over here Kathleen Smith and Jennifer Hutchings.
Right. Question is this: if you accept the premise that part of the statute is to prevent the destruction of recognized works of art, what's the justification for capping the damages for the destruction of a work at $20,000 if, as may be often the case, the value of that work is substantially greater than that?
Thank you. Jennifer, if you'll get on the microphone, please.
So when we went through the lawsuit, the artist, because of my comment of ugly, he tried to say that he had a loss in revenue of over $300,000 that year because of my comment. Not providing taxes, how do we know what he really made? He has over 1,700 murals. I don't know what the value of his is. He wouldn't provide that. I don't know how you place a value on that. I don't know the answer to that question because we couldn't even get it out of the artist himself.
Kathleen Smith, do you want to add anything?
Yes, 2 points to that. First, to support my partner, right, this is an example of her exercising her free expression, criticizing a piece of work that she doesn't like, and then being turned around and accused of violating an artist's moral rights of integrity because her criticism caused that artist some type of damage. That is not what we want to promote here in the U.S., right? We have free expression rights. We have the right to criticize, comment upon, and we should not be counter-sued for those comments. Second point is, the capping, this is not a destruction of property claim, right? If the artist continues to own that piece of property, they can sue for destruction of property. This is a violation of moral rights. And so, yes, the value of the art may be higher, and if the artist continues to own that piece of property, it's a private property right of destruction. Oftentimes here, though, the artist no longer owns the property. And so the destruction is caused by the owner of that piece of property. And the value of moral rights, it's hard to put a monetary value on it, but it's not going to be the same value of the piece of property because it's no longer theirs.
Is there a question for the team against the proposition? Yes, let's go ahead up here in the front. Please give your name.
Good morning. My name is Caleb Frischnecht. In many countries, moral rights are not waivable or licensable as a matter of contract. Is it your position that moral rights in the United States should be expanded beyond visual works? And if so, how do you balance that with the need to create contractual certainty?
Thank you. Sue Liemer and Jen Martin.
You can contract for anything. That's not a violent crime, as I try to tell students. And so you can, if you don't waive the moral rights, you can still come to an understanding of how we're going to protect those rights and how we're going to work within that. We heard the opposite side talk about as if the death of parody and satire would occur if we have moral rights. And again, that's not necessarily the case. I just think the parties have to come to an understanding and add that to the contracts.
Thank you.
I'm
sorry. Oh, sorry. Go ahead. I thought you had completed.
So, we have other rights that you can't waive in the United States. And so, you can't waive your right to self-incrimination, against self-incrimination or something like that. And so I think we can just come to an understanding of what it is that we're valuing here.
Another question from the audience. Let's. Are there any questions on this side of the room? Okay, over here. Let's take in the burgundy. Please state your name.
Hi, my name is Rebecca Bean, and you guys mentioned that it's protected as long as notice is given that it's going to be destroyed or something's going to happen, and you mentioned a 90-day period. Jan said he got a 90-day or should have received a 90-day notice that he could move it. Is there any point at which a 90 days is given and the artist can say, no, I don't want to move it, it has to stay there? Does that ever happen? Is that possible?
Kathleen Smith, do you want to answer that? Sue Liemer? Who would like to go? Why don't you go ahead? Okay, Sue Liemer.
I think it was directed at you.
I don't know that we have any cases where that's actually happened, where the 90 days notice was given and the artist dug in and said no. The statute clearly contemplates arriving at some kind of understanding.
There's a question in the back.
Hi, Trevor Bradford. My understanding is that VAR was enacted in 1990. Given that so few cases have percolated up, doesn't that suggest that it's working?
Jen Martin, Sue Liemer.
So one of the reasons that so few cases have percolated up is because so few people know about the law. And that's one of the reasons I'm glad we're doing this debate this morning, so that more people will know that the law even exists.
Yes, here.
Hi, I'm Bill Rosenblatt. My question is, Jennifer Hutchings and Cathay Smith, you've taken your position based on applicability of the law to visual artworks, and the other side of the debate mentioned that there is no moral right for other types of works, such as musical works and literary works. And how would you make an argument for those other types of works?
Kathleen Smith.
I think today we're arguing that at this point in time, right, we don't agree with expanding moral rights to cover other types of works, including literary as well as musical works beyond visual art. I think there is a concern with the potential to stifle, chill expression. The examples that I gave involving the book, right, the right of integrity, the parody version certainly could be argued to have harmed the original author's honor and reputation because it was poking fun at and criticizing Margaret Mitchell's romanticization of something that we all now understand should not have been romanticized in a very popular book. And so right now we're taking the position that moral rights should not be expanded to incorporate literary or musical works.
And if I could, Sue Liemer and Jan Martin, would you please address the concern that that expanding these moral rights would stifle free expression?
So it's striking because last weekend I was at a symposium in Washington, D.C. on intellectual property law and social justice. And there were some wonderful sessions given about the ways in which historically African-American artists in particular in the music industry have had their work basically just ripped off, right? And they didn't get either the economic or the moral rights protection that they deserved. If we had had strong moral rights protection in place in this country in that time period, in the 20s and 30s, 40s, even the 50s, you couldn't rip off people's work. You would have to get their permission to modify their work.
And I think that is a concern, right? First of all, that it's a horrible story that the musicians have their works ripped off, but we have copyright laws for that, right? That is copyright infringement. That is the reproduction right under copyright law. That is the right to derivative under copyright law. Expanding it to a moral right of integrity could be used in instances such as Two Live Crew making a rap version of Pretty Woman, right? That could have been shut down if musical works had moral rights of integrity.
The classic case that people often cite for the moral, to give an example of the moral right applying to music has to do with the classical music composer Shostakovich. This case is a few decades old. At the time of the Soviet Union, there was an anti-Soviet Union propaganda film that used his music as the underlying soundtrack for this, and his life was actually in danger because of it. And he sued in both the United States and in France, and he won his case in France where his moral rights were protected. They couldn't transform the use of his music without his permission, and in the United States he had no standing because we didn't have VARA yet. We didn't have any protection for moral rights. That's one of the starkest examples for musical protection.
Let's take a question from, are there any, okay, right here in the back. If we could get a microphone over there. Please state your name.
Yeah, my name is Rob Gurr, and I just had a quick question for either side. Sue had mentioned that, there are restrictions that we have on property, right? Whether or not you can change the color of a building or whatever, there are restrictions. Typically, those are recorded, in title somewhere, right? You can go to the recorder's office and you can see those changes. It feels like, with Jennifer, she didn't know, right? It was almost like the artist had an easement or had somehow adversely possessed, that side of the building or something. But at what level does that occur? So with adverse possession or with an easement, it's very clear what has to transpire in order to get that. So at what point does that happen for a piece of art that's on a building, right? At what point does he get essentially an easement that can't be changed? And should that be recorded, in title somewhere? So if I go to the recorder's office when I'm buying a building, I know that I cannot, paint the side of my building, right? Thoughts?
I think if you see an entire wall of a building covered with art, if you know that this is a value in your culture, you don't just go changing the art without asking about it. This is the law in many, many countries, and nobody has to register it. They recognize that is art, that's a cultural object that they can't just do whatever they want with.
Jennifer
I feel
Hutchins.
like that's a matter of opinion. What might you see as art is not what I see as art. I feel like it's very subjective.
Cathay Smith.
And I'm a preservationist at heart. I just don't think it should be done through moral rights, right? We have other laws, and you mentioned those. We have other laws that, such as historic preservation laws, states and ordinances, local ordinances have attempted to enact moral preservation ordinances. There are vehicles that protect art that has properly become the heritage of a community or the heritage of a nation. Artists don't always represent the interests of a community, right? They could be an artist, and moral rights are only go with artists. They're not a community preservation right? An artist could have moral rights in a piece of work that the community despises, that does not fit within a community anymore, right? Let's say it's a famous Confederate sculpture, a famous racist piece, right? The community may hate it, right? And that is not what moral rights does. Moral rights is an artist control of their works. It is not a community heritage.
Would you like to respond, Jen Martin?
Well, it's interesting. From what I read, the community in Oklahoma City recognized the artist. He was somebody who was known to them and known to the state. So to come in and then have something removed without any discussion or any way to remonstrate against it, that has in fact impacted the artist. And of course, once it's gone, then like I said before, that's gone forever. So.
All right, let's take a question back here, and then we'll take one right up here.
Thank you. My name is Drew Thornley. I have a question for Professor Liemer. You mentioned about, we frequently buy things like property that have encumbrances. Totally. I wonder how, if at all, your thoughts change on the fact that that's not what happened in this case of 5 Points. Jonathan Cohen, who organized the efforts, it was an understanding from the beginning that this was a temporary thing. He approached Wolkoff, and this was their arrangement. So it wasn't like Wolkoff bought the property subject to these encumbrances. So that's question number one. And then number two, a point that I touch on in my paper on this is the idea that the property owner, according to VARA, has to seek the waiver from the artists, as opposed to the artist having to get a grant or a license or an easement or something from the property owner. I think that's misplaced. So I'd love to get your reaction to that, too.
And are you Drew, by the way?
Ma'am?
Are you Drew, by the way?
Yes, ma'am.
Okay, nice to meet you. We've exchanged papers.
Yeah, thank you so much for
yes.
To
your first question, the site where 5 Points took place was a dilapidated neighborhood. It was a dangerous neighborhood. There were street artists just doing sort of random graffiti tagging, and it gradually came up. They called it the Fun Factory, PHUN, Fun Factory at first. And then as the quality of the work started to come up, Mr. Wolkoff, the property owner, he did ask Mr. Cohn, who was the lead plaintiff in the case, to help organize what was going on there. And they had indoor spaces and outdoor spaces being used. They had artist studios and workshops in that space. And Mr. Wolkoff, even under oath in court, he repeatedly spoke positively about the artwork. He liked the artwork. He approved of what Mr. Cohn was doing. And what Mr. Cohn was doing was essentially acting as the curator of this artwork. He used a system to determine who got to have their work on what they called the long-standing walls, the ones that were high up. And some of these walls were 5 stories up. And I don't know how you do what the court called aerosol spray art. I don't know how you do aerosol spray art 5 stories up on an exterior wall, but they did. And he determined who got those spaces, which spaces were going to stay up longer. The interesting thing about this case is Mr. Cohn applied a set of rules and values that were known in the graffiti art community that were sort of a subset of the hip-hop community's rules. So they had their own cultural understanding of what was going on there. When could you paint over somebody else's work? Well, if you were a beginner, you could assume that somebody was going to paint over your work really quickly. If you were somebody known, or if you did a really high-quality piece, you were granted respect by the artistic community, and your work was not painted over more quickly. So they had their own subset of rules, and it's sort of like if you're familiar with a hip-hop dance-off, where people sort of, they lay down the gauntlet and one dancer goes and the next dancer tries to up them, right, and do even better. And that's kind of what was happening on these walls. They had tens of thousands of works over the course of many years. Those young artists gentrified that neighborhood. They're the ones who called attention to the neighborhood. They're the ones who made Mr. Wolkoff's property worth $250 million. The entire neighborhood came up because of it. What happened was 5 Points became so popular, it was an international tourist site. It was in the physical guidebooks. It was on the blogs and the websites. When you go to New York City, go to 5 Points. They had thousands of school children taking trips through. And they had a written code. Nothing could be obscene. You couldn't have any swear words. so that you couldn't have any sort of obvious drug references, and so that school children could even take tours of this space. So there was a lot of value added by these artists, and Mr. Wolkoff was frankly willing to just, capitalize on that and not make an arrangement to somehow capture that value for the artists themselves.
Thank you. Kathleen Smith, would you like to respond?
Yes, and I agree with everything you're saying, right? 5 Points was an awesome place, right? The city of New York should have listed it under the Historic Preservation Statute. The artists should have been able to bring a moral rights claim against the developer, and they did, right? Under current laws, they were able to bring a violation of their moral rights claim against the developer, and they were able to win. An expansion of moral rights in the U.S. would not have changed that result, right? He painted it over under color of night. He would have done it no matter what, it sounds like, the law stated. No matter how expansive the law was, he would have destroyed the works anyway, and the artists were able to sue him under our current law for it. An expansion of moral rights in the U.S. would not have changed the result of that case, and so we are arguing that it is sufficient here in the U.S.
But we have lost 5 Points forever.
And it's
not just the local community, but the entire country has lost it forever.
Completely agree. But an expansion of moral rights wouldn't have changed that. Putting him in jail before he could have done it would have done that, but obviously we don't have laws that can do that. But expanding moral rights law would not have saved 5 Points, and we all lament the loss of 5 Points, except for the developer. And he did pay under our current laws.
Well, yes, please address the question. Under what aspect of expanding moral rights would have saved 5 Points?
If we were talking about the equitable remedies, if we put the focus more on the equitable remedies, because the money doesn't. These artists were helped by the money because now they have recognized stature, and all the work they do going forward will have recognized stature. The 5 Points case is the first case where the court applied the standard that the Southern District of New York had articulated in the Carter versus Helmsley Spear case, which was lost at the Second Circuit because it was a work for hire, according to the Second Circuit. The artists won the Carter versus Helmsley Spear case in the Southern District Court. Sorry, I just lost my train of thought there for a second. Because the court articulated a standard of what recognized standard means, and who has to do the recognizing? They said either art experts, the art community, the broader art community, or the community. And so 5 Points is really the first case, at least at the trial court level, because we don't have the appellate decision yet, it's really the first case where the community got to weigh in. The artists got to weigh in, and not just a bunch of people who have PhDs in art history. And so that was the first case where I think, we're actually, we can't even begin to start arguing for expansion, because I think we're just now starting to actually apply the laws that exist. It was the first time the community even got to weigh in as to whether they wanted this art in their community or not.
Thank you. It's now time for, we've run out of time for our questions. That was our 30 minutes allotted. So we are now going to advance to closing statements from our debaters, and thank you very much for the questions that came from the audience. Each team member will now have 2.5 minutes, and we will rotate. We will begin with the team arguing against the proposition, and the proposition again is United States law sufficiently protects the moral right of creators to control their works. We'll start with Jan Martin.
Well, ironically, I was put on this side of the stage because basically my support remains with VARA and is based on the beliefs and experiences of the destruction of artists' creative work must be inhibited. I understand that court cases will accrue and each one will add to the direction of legal thought gathered from different situations, communities, and legal opinions. Individually, you and I may disagree on which has artistic merit, but VARA provides a forum for interpreting these concerns. Frequently in the past, art was destroyed simply because the cities, businesses, or people thought they could. Now VARA stands as a vanguard against such wanton disregard. I am proud that the landmark case of Martin versus Indianapolis provides protection for future art and artists. This was not the outcome for Symphony No. 1 that I had anticipated or hoped for. It is a lasting legacy to the integrity of creation. When VARA was introduced to the House in 1990, Representative Edward Markey of Massachusetts made this introductory statement. Artists in this country play a very important role in capturing the essence of culture and recording it for future generations. It is through art that we are able to see truths, both beautiful and ugly. Therefore, I believe it is paramount to the integrity of our culture that we preserve the integrity of our artworks as expressions of the creativity of artists. Now, I do have two areas that concern me. One is site-specific, because I have a sculpture that's partly in a river and partly on land at a park. And right now, it's not covered under VARA. So essentially, it could be removed without, if they wanted to, and I wouldn't really have any say in that. I'm looking at that and thinking, well, that I might like to have that piece back. I might be able to do something with it, put somewhere else, and maybe they can integrate it into whatever their new designs are. So I'm concerned about that. There was something else, but I can't remember, so I'm going to pass.
You've got 20 seconds, so we can let you think it through. All right, thanks, Jan Martin. We'll now go to the team arguing for the proposition, and we'll start with Jennifer Hutchings.
There's a lot more people in a community than just artists. There's business owners, really, really hardworking people, and I am one of them. I expressed my opinion of the mural and art and my freedom of speech, and I was badgered. It was my personal opinion, and why does expressing my personal opinion become grounds for a federal lawsuit? That's my first question on expression. Private property is the second thing. Why cannot my private property reflect my personal taste if this particular piece wasn't a registered historic thing, there wasn't anything at the title company saying this, mural has got to be dealt with the VARA waiver. So that's the second thing, the private property issue. Who has the rights of your own building? Third, the current U.S. laws, I feel, are more than sufficient. If an artist has the right to take someone to federal court, litigate for 2 years, wasting everyone's time and money and potential taxpayers' money on a jury trial over hurt feelings, why in God's green earth do they need more rights protecting them? I design art for a living. I print art for a living. I love art. I own a graphic company, an advertising company. I reproduce art all day long. 7 days a week, I'm working on art. I love art. I'm not an art hater, and I feel like I would never try to ruin someone's life because somebody's feelings got hurt, or my feelings got hurt because somebody didn't like something that I designed.
Thank you. We'll now go to Sue Liemer. Can I go back to the very first? Sure. Let's see if we can get back there. There we go. Okay, Sue Liemer arguing against the proposition.
So if we go back to the Declaration of Human Rights, which the United Nations issued in the aftermath of the atrocities of the Second World War, protecting the work of creators is covered. And it states in Article 27, parentheses 2, everyone has the right to the protection of the moral and material interests resulting from any literary or artistic production of which he is the author. Author there is used in the copyright law sense to mean the creator of the work. The material interest there is the way Europeans refer to copyright, and moral rights have long been baked into, I argue, I've done scholarship on this for hundreds of years, baked into the civil laws traditions protecting the works of artists. So we have in international law, this is binding law in international law. It's a source that many people will turn to, the Declaration of Human Rights, and moral rights are protected right there.
Thank you. All right, we'll now have closing statements from Kathleen Smith arguing for the proposition.
So artist rights should be protected, right? And U.S. law is currently protecting artist rights. U.S. law is working. We heard 3 cases here today where U.S. law has worked. We heard 5 points. We heard a lot of action, right? 2.5 years of litigation under violation of the moral right of integrity. We heard about Martin v. City of Indianapolis. Yes, we need more clarification in the law. Yes, we probably need more education on the law, but we do not need to expand current moral rights in the U.S. to cover expressive works other than visual art. And so I wanted to be clear, right? Current law is attempting already to balance these various interests, right? Attempting to balance artists' rights with freedom of expression, attempting to balance artists' rights with private property rights. And so my position today is not that we need to dismantle, our position today is not that we need to dismantle or just strike out a current moral rights law that we have in the U.S. The position today is framed by the motion. right? That U.S. law sufficiently protects creators' control over their works. It already strikes a balance, and it should not be expanded to cover more works, expressive works, other than visual art.
Thank you. Okay, so now it's time to find out who won. We are going to take a vote from you, our live audience here at the 2019 BYU Copyright and Trademark Symposium. And as I explained before, the team whose level of support has changed the most during the course of this debate will be declared the winners. So please use your phone or mobile device. Go to meet.ps/BYU Symposium to indicate your opinion on the motion. United States law sufficiently protects the moral right of creators to control their works. If you vote yes, you are agreeing with Cathay Smith and Jennifer Hutchins. If you vote no, you are agreeing with Sue Liemer and Jan Martin. Or you may vote undecided. So I guess the results are going to appear on the screen here. So you can see that before we began, 52% of the audience agreed with the proposition, 22% disagreed, 26% undecided. 78% now agree with Cathay Smith and Jennifer Hutchings, so they've seen an improvement of 26% in their support. 16% disagree, so that was a drop in support. And the undecideds, oh, all right, tied. So we will award victory to Cathay Smith and Jennifer Hutchins, our team in support of the proposition. Congratulations. And let's have another round of applause for our debaters. And if I may, my name is Julie Rose, and I'd love for you to check out the show that I host daily on SiriusXM Channel 143, or you can go to byuradio.org or just ask any of your devices to find the Top of Mind podcast. We do 2 hours a day of live, in-depth conversation about all kinds of stuff, including copyright and law, actually. But thanks again, and I hope you enjoy your afternoon.